Tulis.
The disbanding of the Varnell, Georgia Police Department is on page 1 of the Chattanooga Times-Free Press today, and I would judge that is a good decision to put a story like that on page 1, because after all, it raises questions about the future safety and welfare of the people of that town. There was a 3-1 vote, and in a rather seemingly hasty assembly of comments and motions, the city council 3-1 voted to get rid of the police department entirely. And the causes were not those that we look at here really as much as personal grievances among members of city government and Chief Lyle Grant. You can read the story at the Chattanooga Times-Free Press. Read a few lines of it anyway on page 1 if you're looking at it in the news rack there. Tyler Jett is the writer of that story. It's Whitfield County. Now, the question of policing is of great interest today and in the next couple of weeks as Mayor Andy Burke in Chattanooga weighs the recommendations of his 5-member review panel that gave him 3 names, including 2 from the ranks here in Chattanooga, Edwin McPherson and David Roddy, and then a military man out of LAPD, Los Angeles Police Department, Todd Chamberlain. Now, the question we've raised is, what are the prospects of reform? And that it's not clear where those prospects are, and we're hoping for details about these men. Three of them named. And the chief of police in Chattanooga would oversee a police department that has a nearly 500 officers, armed officers. They have weapons, they have tasers, they have gas, they wear armor plate, and they're beefed up, sort of like personal tanks, men and women in personal tanks, and they are there to enforce the law. That is what they're there for. That's why it's called law enforcement. The interest is security. There is some peacekeeping interest there. There is, of course, some interest in solving crime and attaching criminal acts to individual private criminals. We have private criminals, and these are the enforcers of state law. They enforce state law against all private parties who fall under the statute in some way, and whose actions are forbidden, made liable and forbidden in statute in some form or other. And police, of course, are the main enforcement arm of commercial government, the operation of government by converting free activities into commerce, thereby allowing the police department to regulate and stop and, in many cases, harass people for harmless things that are in commerce by those private people's own confession. Right, they're on the road in commerce, having driver's licenses and the like. They've declared themselves to be common carriers involved in transportation. Right, they are drivers and they have passengers. These are commercial terms, and ignorantly, mostly, they are subject to this kind of enforcement action. It's called commercial enforcement, and is common today, and it's accepted by everybody, including probably the most free market, the most constitution-minded candidate for governor, May Beavers. She in a conversation with me indicated that, well, you really can't have people driving freely under their common law rights. It was a novel thought to her that there could be people who actually do that and do it as a matter of right. Self-consciously, not being involved in commerce away, but traveling privately. It is possible to travel privately. Most Mexicans, Hispanics, Guatemalans, and Hondurans, and others who come here from south of the border are just that. They are private users of the public highway. So the police department is being dissolved in Varnell, and if that vote is not rescinded and these 3 council members boldly march on, they will be needing the services of the sheriff. And that is, of course, the matter at hand. If there is not a police department, a military organization that serves the mayor, in Chattanooga, that's Andy Burke. If there's not a military organization that serves the executive branch enforcing state law, then you have another source of service, and that would be the sheriff's department. Now, I'm not sure about whether Sheriff Hammond in Chattanooga and Hamilton County has authority legally to arrest people and work on solving crimes and running traffic and so on in the municipal corporation. There are questions there about jurisdiction, and in my mind, having read some in the court's rulings about this activity, whether the city police department has legal authority to begin with to enforce statute. There seem to be two major cases that suggest that city corporations have only civil power. They do not have criminal power at all. And yet police departments in Saudi Daisy and Red Bank, in East Ridge and elsewhere run as if they had direct authority to enforce criminal statute in Title 39. So that these are questions that are, in my mind anyway, worth considering. I don't dismiss them. And so in Whitfield County, the sheriff of Whitfield County will have some work to do to maintain the peace and enforce statute in that town. I'm not familiar with Georgia law, so I won't say more than that. But there is other news out of Whitfield County. A couple days ago, well, actually just after 4th of July, Tyler Jett from the newspaper had a story about a Whitfield County Sheriff's Office staffer who shared Social Security numbers. Now, the idea of the government, if the government stops you and in some way arrests you, what it will ask you for your Social Security number. And what happens is that once a municipal authority or a deputy seizes you, your Social Security number becomes a matter of public record, and it's in the court papers. Okay, you need to understand that if you give that number away, you become vulnerable not just to the court, but you become vulnerable to private criminals in the way of hackers and ID theft, because that number is part of the public record. And I can find out if you're arrested. I can find out your Social Security number. Think about that. This is a very dangerous risk. It is a grave risk to people like you. And the story is from the Whitfield County Sheriff's Office, Captain Wesley Lynch, who said that a staffer sent inmate Social Security numbers to the media because she accidentally clicked the wrong option on a software program. And so there was a question of SSN booking and release, an option that sits 2 lines above the usual report. The report selected shows every inmate booked in the last 24 hours, as well as the Social Security number. And so it was these numbers were put out to the public in the press. Now, a responsible journalist, of course, would not take advantage of that and would have no private use for that information. But there are other people who might not be so gracious to inmates whose private data they were able to amass. Now, policing is a growing problem in the country, and there's one I wanted to mention out of Pierre, South Dakota, that the Civil Liberties Union of South Dakota has brought to the public's attention. And Matt Agarist, writing on July 5th at freethoughtproject.com, tells about the forced catheterization of 5 adults and a boy. This boy was the son of Kristen Hunter, 3 years old. And the story tells about police contact with Hunter's boyfriend, who was on probation, and he had failed at routine urinalysis, right? And so several officers showed up at the house of the girlfriend, along with Department of Social Services employees, and demanded that she, Kristen, and her children produce urine samples. Well, Kristen gave a urine sample well enough, but 5-year-old daughter did too. But there was a boy who wasn't potty trained. Now, guess what happened to him? Just guess what happened to him. He was held down, and you might say he was sexually assaulted by a forced catheterization. They just shoved it right up there, and he screamed so bad, Hunter said, because these cops and social workers were apparently filthy at the time, the poor toddler contracted staph infection from the process, and he's still dealing with a staph infection, and we're giving him medication. His mother says, quite frankly, it's cruel and barbaric to forcibly catheterize anyone, let alone a 3-year-old child. And this process raises serious constitutional concerns. That's Heather Smith, who is the ACLU executive director of South Dakota. And the story tells also quotes a man who's among those suing the South Dakota Department of Social Services and a hospital and the Pierre Police Department and the Siston South Dakota Police Department as well as the Dakota Highway Patrol. His name is Dirk Sparks. He was forced into a catheterization because he looked fidgety. He says, it was degrading. I was angry and I felt like my civil rights were violated. He had done nothing wrong, and he was in his house, but because he was fidgeting, the police demanded the authority to test his urine. He couldn't. He wouldn't pee in a cup for police officers, so they arrested him and took him to the hospital. I didn't think they were actually going to go through with it, he said. He had been having pain now for weeks after this incident. Even when we went to the hospital, I thought it was a threat. But once he was in the hospital, 4 police officers held him down while they placed a hood over his head. I'm thinking of Abu Ghraib here. He was then chained to a bed with his pants down around his ankles while a nurse at Avera St. Mary's Hospital in Pierre forcibly inserted a pencil-sized tube into Sparks' urethra to extract his urine involuntarily. He recalls that through the mesh hood, he could see a 5th officer filming the practice. He was being filmed by an officer as a nurse inserted a tube into his penis. This is a kidnapping, right? This is a kidnapping. It's a kind of a rape, I would say. And so these very important and very courageous public officials in South Dakota are being sued for their acts. And we have to ask why do public officials police officers who enter the service with a noble purpose, right? They usually enter with a grand ideal. They want to help people. They know that they'll be dealing with often low life folks, people who have some criminal interest or some criminal tendency, who have bad language, right? They know they'll be dealing with people like that, and yet they do it for a sense of service, right? They want to serve the public. They want to serve maybe their country or their county, and then once they go into the force, they obtain by their training a sense of propriety. Propriety, of course, is property. If you have property, you have a proprietary interest in that property, and whatever's yours, you have propriety in it, right? So propriety is something that you have in something, right? And so police officers often have that sense, and that's why they serve their master, the state, bring in revenue to get DUI or drug busts on the side of the highway. They do that no longer thinking of their high goals. Force catheterizing a 3-year-old child is something that comes only when you own that person, right? When that person is yours and has no rights, is simply your property. It's a slave and master relationship. Just as employment is a master-servant relationship, here policing, mimicking the employment concept, has the same thing. Once you're when you're an employee, you belong to the master for the 8 hours you're on his plant, right? You really don't have say so. All you have is his. Your time is his. Everything you do is under his direction. And so you are in a master and servant relationship. And so that applies to policing as well. So policing, in a way, is not worse than what we have in the American economy today, which is this master-servant connection. Now, there's been an important break in the public dealing with police officers, and that is an appellate court ruling that I read about it from John Whitehead at Rutherford Institute, and also the Atlantic had a story a couple days ago about it. It's Fields versus City of Philadelphia, the Third Circuit Court of Appeals, that says effectively that you don't have to have a publication interest in filming cops, because the district court in a cop filming case involving 2 people who were acting on a sense of civic duty, right? They were taping abuse. They were taping what the public servants were doing. And the district court said, well, no, you were properly arrested and you had no right. You had no right to film because you were not part of the media. And my argument is, well, everybody is in the media today. even you, my listener, you are part of the media. And I encourage you, as you see things that are of public interest, of civic interest, that you let us know, right? We are here, David Tulis. We're brought to you by Nooganomics.com. That's a website for the man who matters in Chattanooga. It covers the deep state in the context of Tennessee. There is a deep state narrative, even on the state side. It's not purely a national phenomenon. We have that here. And the deep state narrative, in 2 words, is called commercial government. And that's how it operates. It sounds kind of boring, I know, but it really is very thrilling. When you think of the great abuses by the state, every state is like Tennessee. Tennessee is not really different from any other in the country. They've all been converted into small Washingtons. And so that is what we cover. We would like to hear from you. If you, my listener, have a story of abuse, or a story of an officer or a regulator or an official acting outside of his authority, simply let me know. This is David Tulis, and we are at 800-8949, 800-8949. So Richard Fields and Amanda Garassi brought their suit in separate incidents. Garassi is a member of the local police watchdog group, was filming officers arresting a protester during an anti-fracking demonstration in 2012 when one of the officers pushed her against a pillar to obstruct her from recording the arrest, and then Fields used an iPhone to film police breaking up a house party across the street. An officer arrested Fields, who was a Temple University sophomore, and searched his phones for the videos. He was not arrested, and these two filed lawsuits against Philadelphia under federal civil rights laws shortly thereafter. And the district court rejected their arguments. It said that the First Amendment argument, citing the lack of existing precedents from the Third Circuit or the U.S. Supreme Court, the judge noted that neither this is the story here in Atlantic Monthly. The judge noted that neither Fields nor Garassi testified that they had an intent to publish or distribute the footage when they took it. Accordingly, the court said, quote, "We decline to create a new First Amendment right for citizens to photograph officers when they have no expressive purpose." Okay, the expressive purpose argument. When they have no expressive purpose, such as challenging police actions. But the Court of Appeals rejects this idea. In other words, the idea that you have to be a publisher, you have to be connected with the media to have that right. Now, I have that right because I'm in the media, but why shouldn't you? And if you remember, not long ago, I challenged the county clerk's office, saying, I may be a member of the media, but I'm here asserting my right to film this place here, this sort of a courtyard in the building off of Bonnie Oaks. I have a right to film this as a member of the public, right? I don't have to be a member of the media, but I'm asserting that right privately and personally. And do you plan to arrest me if I run my camera? And a great compromise was made. Everybody who dealt with me there initially in a kind of harsh way, we all came to a very amicable agreement that I could make my video there as I was looking at people in the line. Whether I have an expressive or publishing purpose or not is irrelevant. It doesn't matter whether I'm a real newsman or just someone with a smartphone. So many people have smartphones, and we encourage you, the listener here at Nooga Radio, to record anything of interest, anything of value. Don't forget, you have rights and you need to assert them. As we mentioned, your rights don't exist. They don't exist unless you assert them. You have to assert them the moment they're challenged. The moment you're told no, that's when you have to say yes. Or when you're told you must, you say no. Okay, your no is important. And I've been thinking a lot about this. I've been hearing some real fine legal lectures in the past few days about arrest. And arrest is a very important doctrine. And to know when you're under arrest, to know what your rights are, and to see the games that officers play, often with great violence, often with loud and abrupt and angry exhortations and accusations and threats. That's what you get from many police officers. Now, police reform in Chattanooga may address those questions kind of on the margin, as we have heard about them in the Hanson-Melvin case. But fundamental reform in Chattanooga would bring to the forefront of training the 4 points of reform, and that is the use of time, space, cover, and de-escalation. I don't know whether David Roddy, Edwin McPherson, or Todd Chamberlain give a hoot about these reforms, which are already they're already part of the narrative in policing, right? You can't avoid them. As I asked Chris Ramsey, who is one of the group that chose these three men, I said, this is part of police life now. The ideas of reform. Officers are trained near 60 hours in killing people, and they get about 8 hours or so of training of how to negotiate with people who may be mentally unstable, who may be non-compliant for a reason. Right? Why does everything have to be done right then? Officers need to be citizens first. Wait a minute. The word cop comes from citizen on patrol. Maybe we need to have cops again, real citizens on patrol, and not professional soldiers, which is what policemen have become. They like being soldiers, but maybe the people want something else. Maybe the people want reform and want to have, rather, citizens on patrol. They're on the public payroll, but they are citizens. David Tulis.
In-depth traffic, news, and information. Mornings on Nooga Radio, AM 12.